All right, everybody, come on in. It is Friday. It's the Democracy Stupid. I'm Edwin Eisendrath. I'm joined today again by Adam Klasfeld. And look, Adam is a legal journalist. He is the owner and editor of All Rise News. His focus is the judiciary. He is a terrific reporter, a very clear writer, and my God, his work ethic is exactly what this moment requires. Well, the last time he joined us, and for those of you who might remember this, he had to step out of a courtroom in Wisconsin into an absolute wind tunnel to join us to report on something really important, and then we may actually have a follow-up too. But Adam's he really is paying attention to what's going on in the American judiciary, and that is one of the enormously important pillars of our democratic health, but also of possible democratic demise. So, Adam, welcome.
Thank you so much, Edwin, for that very kind introduction. Always a pleasure talking to you.
Hey, I want to take a break from what you and I both do, which is to report on you doing primary reporting, me talking about the sort of daily outrages from the administration, and zoom out just for a little in this conversation and get your sense of where we are as a nation designed to be one of laws, not men. I mean, and as I understand it, per John Adams in the day, that's a nation where the rule of law applies to everyone, where laws are made by our representatives with our consent, where no one is above the law and no one can dictate the law. Right. And so I thought about this, and I'd love to get your take on where we are, particularly as we look at like vindictive prosecutions or prosecutorial misconduct. And then we can spend some time on the Supreme Court. But let's start with your general sense about this, and we'll dive in deeper.
So to use an analogy, I would say the antibody response of our democratic order and rule of law in general has been strong. You mentioned vindictive prosecution. I have not seen a successful motion for vindictive prosecution in nearly 2 decades of covering the courts until Kilmar-Abrego Garcia. It shows that a very difficult motion for any criminal defendant to prevail on, that when the conditions are ripe and a judge faithfully honors the law and the basic principles of prosecutorial fairness, that these concepts are not only on paper, it can actually be applied to some of the most powerless people among us. So that shows a healthy antibody response. When the Trump Justice Department wants to establish a $1.776 billion slush fund, there has been a strong antibody response. And now there is a court order blocking its machinations. There is Todd Blanche claiming before Congress that it is not going to be moving ahead. And there is the possibility of another federal judge in Florida deciding that the entire thing is a fraud upon the court, which could have very serious ramifications from the people behind it, including Todd Blanche. Now, on the flip side of that, there is a tremendous amount of ongoing stress on the system. One of the people who will be investigated in that Florida process is going to be Todd Blanche, who has now has the nomination to be elevated from an acting position to a permanent position. He presides over a Justice Department that has lost about 1/4 of its staff, that has suffered embarrassment after embarrassment as grand juries reject their cases in a kind of level that it probably has no precedent in the U.S. criminal justice system, that the legal system is not used to a grand jury rejecting so many cases, because typically grand juries only see the government's case. They have a low burden of proof, and only a majority of them need to agree to push a case forward. And so all of these things that were lightning strikes, that were things that we would never see before. We are seeing judges calling out this Justice Department for grand jury misconduct. That is happening not only once, but multiple times, and that judges are considering whether to open up grand jury transcripts over longstanding principles of secrecy, that you have judges across the country saying that the presumption of regularity no longer stands. That it is evidence both of antibody response, of that holding up, those systems holding up, and the Trump administration encountering real and tangible defeats. But I don't think we're through the woods yet by any stretch of the imagination. I don't think that the $1.776 billion slush fund is dead yet by a long shot. And even if it were dead, that this Justice Department wouldn't find some other way to reward January 6th rioters who worked for Trump on January 6th. I think that there is a lot of reason to have optimism and wariness about where we stand 1.5 years into Trump's.
Yeah. So I guess I have to ask, I think it's an obvious question, but it bears asking. The Trump administration says, see, look, all those things Adam just said, we are being treated worse than any administration in history. These judges are doing things to us they never did to anybody else. These grand juries are filled with liberal Democrats who are doing things to us that no one's ever done to anybody before. We're just trying to get a fair shake. How much bullshit is that?
It's entirely bullshit. I will say this. This is not Trump's first term. This is his second term. If this were a politically motivated thing, where was this sequence of events during Trump's first term? And that's kind of the core.
That's a very good point.
And this is the core of Trumpism, that explain away the defeats by escalating and broadening the nature of the conspiracy. That, if Trump appointed judges are ruling against us, they're part of the conspiracy too. They are never Trumpers that got in because of the Federalist Society, which suddenly they are against or claim to be against when those judges rule against them. And it's the core of it, that it can never be explained by an unprecedented level of malice. It can't be explained by an unprecedented degree of incompetence. This is why I find it so important to go very much into the weeds about the reasoning. Why did a federal judge throw out the case of Kilmar Abrego Garcia? Because Todd Blanche revealed the vindictiveness on national television to Laura Ingraham. That is the reason. I go through the reasons and the reasoning of the judge in this case, U.S. District Judge Waverly Crenshaw, because I think Trumpism thrives on distrust and destruction of the institutions of the democratic order. And
remind everybody, Waverly Crenshaw, appointed by a Republican, right?
Actually, no, he was, and this I do have to. So he was appointed, I believe, by Obama.
Well, was he? I apologize.
No, but that's quite all right. The fact of the matter is that there have been many Trump appointees. There have been many Republican appointees. There have been some of the most scathing rulings against the Trump administration have been by Reagan appointees, to the point where it's become almost a laugh line in the legal journalism community, that the revenge of the senior staffers from Reagan.
But wherever he came from, his opinion with the Abrego Garcia case is worth just reminding everybody what the government did, right? They took this poor guy who they admit they deported illegally. Right. And they said, we are powerless to bring him back. He's in the power of another country now, which was a lie, because they brought him back. But when they brought him back, they immediately arrested him on and charged him with a crime in Tennessee, I think. Correct. Right. And talk about just talk about that and why it's a vindictive prosecution. People
absolutely. And so to your point about the judges having a bipartisan rebuke, when you mentioned that the Trump administration was forced to return him from a foreign gulag, basically CCOP prison in El Salvador, to the United States, that was after a 9-0 ruling by the Supreme Court. including Thomas, including Alito. The entire court said that, yes, they must facilitate the return of Kilmar Abrego Garcia. And so after he wins his return to the United States, and the government decides to prosecute him, they return him to the United States, not to reunite him with his family in Maryland, but for prosecution on immigrant smuggling charges in the Middle District of Tennessee. And in explaining that decision, Todd Blanche goes to Laura Ingram's show and says that the genesis of the investigation was that a federal judge, a district court judge, Judge Zinis in Maryland, questioned their spiriting Kilmar Abrego Garcia illegally out of the country.
Yeah.
And that is definitionally vindictive prosecution. Vindictive prosecution means the government is prosecuting you because you stood up for your rights. And so the reason why Kilmar Abrego Garcia won the right to look for evidence for vindictive prosecution in the first place, that was the centerpiece of their case, cited by Judge Crenshaw in opening up discovery and shifting the burden of proof. At that point, the government, once in legal terms, Kilmar Abrego Garcia brought a prima facie case of vindictive prosecution. There was a plausible case of vindictive prosecution, so the government must overcome the presumption of vindictiveness.
And they were not do it.
They couldn't do it, and they refused to do it, more to the point.
And there are going to be other cases. I mean, maybe the Southern Poverty Law Center. Talk about what's going on there.
Absolutely. Thanks, Edwin. The Southern Poverty Law Center, they have brought a number of motions. They could very easily argue that they have been vindictively prosecuted, and I believe that they have already. What the SPLC, the storied civil rights group, has been accused by the Trump Justice Department of having committed wire fraud on donors by saying that they are fighting hate groups, so that they have historically done that. Because of their informant program, they, for many years, had an informants program where they would gather information on groups like the neo-Nazis and the Ku Klux Klan by basically recruiting people from within those organizations to provide information. And we now know, because of this indictment, some of the fruits of that informants program. We know, for example, that one of their informants provided information on a would-be terrorist in Las Vegas who was going to target a synagogue and an LGBTQ bar. And that this informant, because of that information, the would-be terrorist was prosecuted before that plot could pan out. That another person who was a white supremacist and sought a security clearance in the Philadelphia Navy Yard was stopped thanks to the informant program. But the DOJ's theory is that there is not enough hatred and racism to go around, that the SPLC is manufacturing racism so that people will be scared and send donations to them, and that those donors were defrauded because they were told that the SPLC is trying to dismantle these hate groups, when in fact they were trying to gin up hatred that didn't previously exist in order to get donations. It is an absurd argument, but it is what they are criminally charged with institutionally. There are also counts of money laundering that relate to the manners in which these informants were paid, that these informants were not collecting money from the SPLC in a check that says your friendly local anti-hate watchdog. It had the name of a kind of straw company. One was, for example, posing as a rare books company. Presumably so that the other folks inside these hate groups wouldn't catch wise to the fact that they had an informant inside the ranks.
Police departments, by the way, do this all over America.
It's as does the FBI.
That's what the FBI.
And the SPLC worked hand in hand with the FBI until late last year, when Kash Patel stopped those ties with the SPLC.
Wow. So, and I guess James Comey might make the same case.
Absolutely. I would expect it. He was going to make it in the first prosecution against him that collapsed because he was being prosecuted by an illegitimate appointee, who was Lindsay Halligan. If it didn't collapse on that, I think that he would have very much tried to advance the vindictive prosecution case. And it would have been, again, I've covered the courts for nearly 2 decades. Kilmar-Abrego Garcia was the first case where it actually worked. I think that the case for vindictive prosecution is almost more clear-cut with James Comey, because you have Donald Trump himself saying,
ordering it
in a direct message, or what would have been a direct message to Pam Bondi. And that's just the lay of the land here. So these things that have never happened in the past are happening with frequency because of the shamelessness and the incompetence of this particular Justice Department.
All right. So taxpayers have lost so much because of these terrible people. But if you have a case dismissed because of vindictive prosecution, do you not now have a civil suit against the government?
Potentially. It is very hard in certain instances to bring a successful lawsuit against the government, but there are examples to the contrary. And sometimes, I'll give an example when it involves a local prosecution. The Central Park Five, who now the Exonerated Five, they successfully sued their prosecutors in New York for bringing a case that took away so many years of their lives in the Central Park rape case. So it has been known to happen. There is the possibility of civil accountability. People often ask me, does Kilmar-Abrego Garcia have a case? And, because he is the rare criminal defendant who can say, I have succeeded on a motion for vindictive prosecution, one would typically think yes, but right now, Kilmar-Abrego Garcia is still fighting for his ability to stay in the United States with his family. And the latest battle that he's facing is whether the government can send him to a country to which he has no connection, like Liberia, or where he has volunteered to go to Costa Rica. So we are now at a phase where things that have been adjudicated as vindictive actions that you would think, okay, well, someone is entitled, if you have been wronged by the government, if the government has violated your civil rights by essentially abducting you from the country into a foreign prison when you haven't even been accused of a crime at that point. Remember, when Abrego was spirited out of the country, he was not yet charged in the criminal case. And so there are so many violations upon violations of his civil rights, but we're now at a phase where it's almost premature to talk about any compensation for him.
That's fair. Yeah. Right, so we've gone through a few cases of the vindictive, the abuse, the misuse of should we go show me the man, I'll show you the crime, right? As Beria said in Russia. There's also prosecutorial misconduct, and I'm in Chicago, where the Broadview 6 case is making its way across the whole nation, as people understand, and it's not over. Right. And you have the Judge Boasberg saying, turn around the planes, and going to court and lying to him and saying, gee, Judge, no, we can't do that. They're already gone. They haven't gone. They're gone. Too bad. Maybe Hannah Dugan is another case of this. And I know that one is of interest to you. So just talk about not just the vindictiveness, but the misconduct that gives that vindictiveness a path into courts.
Well, the Broadview 6 case is just entirely jaw-dropping. And as you noted, yes, it's a Chicago story, but it engendered national conversation because I have not seen a case where you can demonstrate that the federal government withheld the fact that a grand jury rejected the first indictment. Again, this is now happening so frequently that we forget how extraordinary it is on its own. But then after her first grand jury refuses to indict, there's ex parte communications with the grand juror outside of the grand jury room. There is a prosecutor vouching for the charges where they're encouraging the jury not to rely solely on the evidence before them, but their own reputation, saying we wouldn't have brought this if it wasn't good, in essence, and excusing grand jurors who are skeptical of the government's case. And you add all of that misconduct and then have the final misconduct of redacting all the evidence. And that is what Judge Perry found so astonishing. That's what I think every legal expert I've spoken to, and I myself, found so astonishing, even given what has happened in the past 1.5 years. This is just a degree of misconduct.
And Adam, let me interrupt for 1 second. The redaction, so everybody knows this. The hiding the evidence wasn't even meant to be. It was just for the judge. The judge said, "Hey, this isn't public, but I've been asked to look at this, and you've agreed that I should. So show it to me." And they lied to her. Correct.
And that's why if you read the transcript of the exchange between her and the government, she is very seemingly livid. It just seeps from the cold record by what she's seeing. She says the presumption of regularity has been broken, and there is a serious possibility of court sanctions that she's going to. The now erstwhile defendants say the charges have been dismissed. The former defendants are demanding discovery. This isn't going anywhere, and there can be serious repercussions for the prosecutors who did this.
Including the U.S. attorney here.
Including the U.S. attorney. Right. And he is trying to distance himself from it, and we'll see how much Judge Perry finds that credible.
Yep. And so it's really interesting. And do you want to talk at all about Hannah Dugan and where that is?
Absolutely.
And the 9 people?
Yeah. And again, to talk about things we had never seen before. Now, we will see what happens. Judge Dugan, now former Judge Hannah Dugan, she resigned, after her conviction. She was convicted of obstructing an official proceeding in a mixed verdict late last year regarding an incident in April 2025 when there was an undocumented immigrant who was a defendant in her court, that there were ICE agents in the hallway, and she let this defendant in her court go through another exit that went to a side hallway. He eventually left through the same hallway where the ICE agents were waiting, but the government alleged and a jury found that she was effectively trying to stop his arrest by ICE agents. The defendant's name was Eduardo Flores Ruiz, and she was convicted. Where this case stands now is that she stands a very real chance of having her conviction overturned and being acquitted of the charges. I was just recently in Wisconsin, in Milwaukee, for these oral arguments on this, because the case that the government brought for obstructing a proceeding were so novel that we were in this rarely tested legal ground. And the law has changed since her conviction, where a court in the Fourth Circuit Court of Appeals overruled a obstruction conviction of an undocumented immigrant who escaped his own immigration arrest. Right. And the argument is the government is putting a 5-year felony for anything that relates to an ICE arrest on an administrative warrant. And it's important to note there was no judge-signed warrant for the arrest of Eduardo Flores Ruiz in her courtroom. It's also important to note that Milwaukee County Circuit Court, like many court systems around the country, have been up in arms and alarmed about ICE enforcement in their courthouse, because if one is an undocumented immigrant and a victim of a crime, you are less likely to try to seek justice through the court system if you think you might be arrested and deported. And
Adam, let me interrupt again to see if I understand what you're saying. So the position of the government is that the executive branch, without any judicial, signs its own warrant that says we want Adam, and there's no judge that looks at it, and they sign that warrant on January 1st, and they're looking for you for 2 years. Is any time in that 2 years a proceeding? And if anybody gets in their way in that 2 years, are they going to go to jail for 5 years? That's what the federal government says.
That is the breadth of the government's argument. As a matter of fact, I was in the oral arguments over to where now former Judge Dugan is trying to overturn her conviction. And the judge pressed the government of, how long have we been in proceedings? This is about 15 minutes into oral arguments. Is this 15 minutes or is it 2 years? And the government said the proceeding is very context specific. So it's not time limited. There is no oversight outside of the executive branch. And the only federal appeals court, according to the defense, that has chimed into the specific question of whether an ICE arrest backed by an administrative warrant is a proceeding that carries with it the threat of a 5-year felony sentence. It is the government's own decision to sign its own warrant. The Fourth Circuit said no. And so the law has changed. And
so that's really important, because if the executive branch can say, okay, look, for any period of time, we have a proceeding to get rid of people we don't like, and you get in our way, we can put you in jail for 5 years. That is game over for civil society. So
absolutely. And it's game over for the ability of courts to regulate their spaces and defend the integrity. This is why during her trial, now, one of the government's star witnesses was her colleague on the on the Milwaukee Circuit Court bench. But there were we have learned through her trial how the court system itself reacted to this. And there was a lot of fear, confusion, and anger about this policy, and that judges didn't know what their rights to control the courtroom and what guarantees they could provide victims of crime, criminal defendants, about the integrity of their courthouses. Are hallways safe spaces? Are their own courtrooms a safe space? And those were things that were being internally debated within the court system. And so if she succeeds, I want to, set up the stakes here. If she overturns her conviction successfully, not only does this remove one of the rare victories that the Trump DOJ has from the ledger, it also eliminates one of the arrows in their quiver to try to pressure local court systems to get along with the program, that the Immigration and Customs Enforcement, ICE's right to be in the courtroom and conduct arrests in the way that they want to, doesn't, they can't threaten judges with with this particular felony charge.
Well, I agree with all of that, except maybe arrow is too quaint. It's a bigger weapon.
Oh yeah, that's true.
Much all right, so we've talked now about sort of the vindictiveness of the DOJ, of their misconduct in order to carry out that vindictive intent, and you rightly given us hope that the system is holding, that is, as you say, the antibodies are there. So I want to talk to you about the Supreme Court, because all of these antibodies you're talking about roll up ostensibly to a Supreme Court that's supposed to tell us what the law is. And I guess I want to ask you about the Voting Rights Act. I was heartbroken by the Calais decision, even though I knew it was coming, because it's been long. But a week later, they sent a quick case back to Alabama, and they said, no, the Constitution's the Constitution. If you find that it is all about race, that's still protected. You can't do that. And then they said, fooled you, didn't mean it. I want to get your sense of that. I don't understand how the Supreme Court can change its mind in a week, but can also say we care. The factual records are established by lower courts. That's the way it works in the United States. But in Anderson, in Colorado, we're going to ignore the factual record. And here now, in this case, we're going to ignore the factual record. What's going on?
Right.
And how do we protect the rule of law in that world?
That particular case in Alabama is just a uniquely astonishing decision for folks who cover the courts very frequently, because it really it lends to Justice Ketanji Brown Jackson's characterization that it's Calvin ball, that there are no rules and you're looking for an outcome determination. And it also says that Justice Kagan was right in the Calais decision when she said the Voting Rights Act is a dead letter. Now, here's what and I think you're right, Edwin, that it wasn't a surprise the way the Calais decision turned out. But this was how
this one was. Alabama, this Alabama one caught
the Alabama one was surprising. And here's why. You had Justice Alito claiming the way that he billed the Calais decision is, we are not gutting the Voting Rights Act. We are updating the test to determine whether there is racial gerrymandering. He said it isn't an intent test, even though he inserted the word intentionally in it. But in Alabama, the map that was stricken specifically on the grounds of finding that the state of Alabama intentionally racially discriminated in the creation of these maps against Black Alabamans.
Yep. And to go back to the correction, you corrected me earlier. Thank you for doing it. In this case, 2 of the 3 judges who found that were Trump appointees.
Absolutely. 100% correct. That 2 of the 3 judges who received the case pointed to the fact that Alito in the Calais decision said that the Milligan case, the Alabama case is the Milligan case, said that that case would survive. So the 3-judge panel in Alabama that was reviewing this reviewed the Calais decision, said this is consistent with the Calais decision. And we have made detailed findings after a lengthy trial with numerous witnesses and more than 100 exhibits that this was intentional racial discrimination that would violate the 14th Amendment to the Constitution and also violate what remains of the Voting Rights Act. The Supreme Court took that factual record and 6-3 said, no, we're going to reinstate this map that was found to be racially discriminatory, at least revive it on a motion for a stay. And that's what I think has shocked the legal community, that it feels so brazen. It feels like such a demonstration of what Justice Jackson called Calvin ball of the Supreme Court, looking for anything to latch onto, that there's no rules, just the preferred outcome, which at the end of the day is Alabama. Republicans have 1 more seat in Alabama at the expense of racial discrimination against Black Alabamans.
And the court doesn't I disagree with many things they do, but they don't usually speak in just the absurd double speak that you hear from the administration. But in this case, they also said, and it's too late to go and change the maps, but they're in fact changing the maps.
100%. As a matter of fact, this 3-judge panel with 2 Trump appointees, as you correctly noted, that this 3-judge panel pointed out that was the whole argument, the Purcell principle, that don't interfere so close to the election, doesn't really apply here, because what would cause the chaos would be reverting to these old maps. That the process hasn't begun. We have this court-ordered remedial map that is ready to go, that local election authorities are trained in, they're prepared for. We are merely that everyone used, that they were merely preventing the chaos and confusion that would result from swapping that map with a racially discriminatory one. And the Supreme Court turned that on its head, saying that, oh no, the Alabama court, this 3-judge panel with 2 Trump appointees, had gotten it wrong because we're too close to the election. Therefore, we need to start all of this chaos. That's the word that Sotomayor used in the dissent.
Mhm.
And she warned about the chaos that is going on as we speak in Alabama.
So you began by talking about how the antibodies are working,
Right.
but at the very top we have this. We clearly have a Supreme Court that has. I mean, I don't think I'm an outlier in America. I have lost all faith and confidence in the Supreme Court as a body that's supposed to tell us what the law is, and instead I see it as a political body using its robes to write to stop laws it doesn't like and to impose laws that it does, and to play timing games that I recognize from Chicago politics that are that are just no matter it doesn't matter that I'm not a constitutional scholar and can't understand all of all the precedent they talk about. I understand the politics. I understand you decide to do something now instead of later. You decide that it's okay to do something now or not okay to do something now. And these decisions there's no way to understand them except through a political lens.
Right. When I say that the United States has shown over the past year and a half a strong antibody response, I don't say that in a way to contribute to false hope or illusions about institutions as an abstraction. We need to see the world as it is. What I mean by this is that the antibody response is people demonstrating on the streets. It's civil society fighting back. It's the fact that this 3-judge panel with 2 Trump appointees did write a very detailed opinion that acts in part to alert the public to what is going on, that there exists this record that the Supreme Court has spoken in this instance, and now it's up to civil society, it's up to voters, and that the antibody response isn't the institution in the abstract, it isn't the Supreme Court, it isn't even the judiciary. It is people being able to use actionable information in defense of democracy and the rule of law. And setbacks aside, there have been other victories for the rule of law in the Supreme Court. There are no longer the military on the streets of major American cities.
And that happened when they were coming to my city. Yep.
Right. And that was something that seemed that Trump was using or was arguing at the time that he was using an unreviewable power. That power has been disarmed unless he wants to invoke the Insurrection Act, which has a political cost, and he hasn't done that yet. I don't want to observe that the immune response of our body politic is strong, is not to have a sort of complacency that, okay, it will protect us.
No one who reads All Rise News is going to accuse you of complacency.
and that's the point of All Rise News, right? That it's the play on words on it. It's the courts, but it's us standing up.
Yep.
And so we are, as a body politic, the immune response, and that the attacks on the rule of law and the constitutional order have been so strong that even with these setbacks, I am impressed at the resiliency of U.S. democracy at this point in our history.
I am too. I think in the end, when we win, we can be very proud of standing down this threat. All right, one more thing about the threat, and this brings us to today's news. So Trump wants Todd Blanche to be the chief law enforcement. I take it back. The boot carrier to himself, who he thinks of as the chief law enforcement officer of the United States, but to run the Justice Department. And as we speak, there is an investigation whether Blanche is a party to a fraudulent deal to steal $2 billion from taxpayers. and to make Trump forever immune from whatever he steals as president.
Correct. I think that is the perfect way to put it. I don't have folks ask me, will Congress, will the Senate confirm him? And I see Tillis already doing some negotiation saying that, well, he certainly won't have my vote if he goes ahead with the slush fund. That seems to be a sort of bargain making. I don't know if Congress is the check on it, but I think
Congress could be the check on it.
Could be. It is
designed. They gave him another couple billion and a half. What did they give him for ICE yesterday? For more ICE agents to be on the streets. I mean, this Congress is not. I think they'll approve him. I think they've approved every one of his nominees. But there will be an enormous price to pay, because the moment he's nominated, somebody's going to find that he's involved in a criminal conspiracy to steal $2 billion from us.
Right. I mean, he's not running on his record, and the things that we have never seen. I've never seen a banner with the face of the president of the United States outside of Main Justice. There's not been the personal attorney of the president of the United States being being the top leadership of the Justice Department being fully staffed with the president's personal attorneys. He's not alone in that. You have Stanley Woodward as the number 3 spot, who represented Trump's co-defendant in the classified document case. You had Pam Bondi was the impeachment lawyer, and the Solicitor General of the United States argued for him in the Supreme Court in the immunity decision. Just today, I was thinking about that immunity decision, because I remember when that was coming to a head, that one of the hypotheticals that was answered by Trump's then personal attorney, John Sauer, that could Trump order SEAL Team 6 to abduct a political rival and assassinate a political rival. And the answer to that was effectively yes. And the Supreme Court endorsed that decision. Now, why am I thinking about that today? Because today, in oral arguments in the DC Circuit, there was arguments over the East Wing of the White House and the challenge over that. And one of the hypotheticals brought by Judge Millett in the DC Circuit to the Trump DOJ was, are you saying that the Trump White House or the government can't bulldoze the Statue of Liberty, and if they do it quick enough, no one has standing? And the Trump DOJ effectively said, yes, no one would have standing. And it really struck me as one of those moments that this is a continuation of the breadth of the sweeping powers that they are seeking. It underlines the importance of this fight over the East Wing, because they really are expressing a vision of this boundless presidency that is dangerous and is also something that could prevail. This idea of presidential immunity was ultimately endorsed in large part by this Roberts Court. And now they have expressed another principle, that there is no standing if they wanted to effectively demolish the Statue of Liberty.
Or the Lincoln Memorial, because, the Civil War didn't happen, I guess.
Right. Which is absolutely. And having the Arc de Trump dominate the news, that. Well,
Adam, I like that one. Honestly, I want him to build that for one reason only. When they finally lose, we can get rid of our national deficit by offering every American one swing with a sledgehammer for $10. And there'll be a line from Washington to San Francisco and back for the privilege of knocking that piece of crap down.
Right. And Trump's name coming off the Kennedy Center.
Sell tickets for the day we tear them down. Okay, that was supposed to happen. He was given 2 weeks to do it. When's the deadline?
I think it's imminent. As I understand it, it was something like I don't want to say the exact date, but it might be coming up as soon as a week. Yeah, there
Oh, I
was
can't wait to see that.
the deadline was expressed sometime last week, and
If
it
they
is
comply, it'll be at 3 a.m. They take them down.
right.
You know? Yeah.
Absolutely.
Adam,
So
thank you. Listen, I've taken so much, 45 minutes of your time. It flew by. And I wanted to ask you about, Jack Smith's report, and we'll ever see the light of day. I got a bunch of other topics, but we'll do it another time. Just tell everybody how to find All Rise News.
thank you so much, Edwin. Folks can find All Rise News by visiting www.allrisenews.com or All Rise News on Substack. And if you become a subscriber, you'll find all of our dispatches right in your inbox, and you'll be supporting the work that I'm doing covering these cases all around the country.
Yeah, and it's worth supporting because Adam's work is making up for deficiencies in journalism all over the country. And he works unbelievably hard, and he makes these issues remarkably clear. So you don't have to be a legal scholar to follow them. Really important. Adam, thank you. I'm greatly appreciative.
Thank you so much, Edwin. Always a pleasure. Look forward to our next discussion.
Me too.